for 5 minutes.
Thank you, Mr. Chairman. I want to thank the witnesses for being here. Last Congress, I introduced the Employee Act, a bill that would have allowed participating employers to receive a subsidy from the state for the wages paid to an individual eligible for unemployment compensation. This concept of my bill is similar to the one in the 2012 UI reforms included in the Middle Class Tax Relief and Job Creation Act. This act allowed states to apply for waivers in order to use unemployment funds to pay for reemployment programs. In April 2012, the Department of Labor issued 24 pages of burdensome application requirements. To the best of my knowledge, Texas has been the only state to apply for a waiver. This is concerning, as many states have been working diligently to expedite the reemployment of individuals receiving unemployment benefits. Mr. Hobby, you have experience with regards to reemployment services and the impact these waivers would have on states. What changes could be made to improve the UI policy?
In our written testimony, we indicate two changes that we think would be helpful that my association supports. One is to add a provision for reemployment bonuses for UI claimants to provide incentives for the individuals to go back to work sooner than they otherwise would with a bonus. And there have been evaluations of that approach that indicate that would be cost effective. Secondly, of course, I also mentioned additional federal funding would be helpful. Third, the way the Job Creation Act is drafted, it embeds training with the wage subsidy in that particular paragraph. And what I would suggest there is you separate out the training and have two provisions. One would be for wage subsidies only, and the other would be for wage subsidies with the training for a kind of on-the-job training program, so that states could also run just a straight, simple wage subsidy program in addition to the on-the-job training program. And then also, I think there's a problem with paying the subsidies off of the weekly benefit amount. Each individual has a different weekly benefit amount. That can be hard for states to administer. I would suggest following something similar to what Utah has done or Texas, with just a flat amount that would be provided for a subsidy to an employer to employ an individual for a certain amount of time, and then maybe an additional subsidy if that employee is retained an additional amount of time beyond that. And then finally, I would also suggest the subcommittee take a look at sections 1115 and 1110 of the Social Security Act, which provides permanent demonstration of authority for other programs in your jurisdictions, such as supplemental security income. There may be some provisions in there that you could use to set up a permanent demonstration authority for unemployment insurance, too, which is excluded from those provisions.
Thank you. I'm going to come to Mr. Williams before I do that. Mr. Kidd, in regards to drug testing, one of the witnesses testified that those that test positive were negligible. In your business, do you do drug testing?
We do drug testing.
And what is the percentage of people that test positive?
Between 15 and 20%.
Would you consider that negligible?
I would not consider that negligible. And 80% of our clients require drug testing.
And the biggest concern, of course, with someone who tests positive is if they go out onto the workforce and are working and they injure somebody. That's a problem not only for you, but for the business.
It absolutely is a problem. Many people forget that many of our employment clients are factory workers. And if you were to send somebody that's on an obit or cocaine or something like that, and they're on a production line, it's very possible they could cut their hand off or drive a forklift into somebody and hurt somebody else, or even kill somebody. We're not going to take that risk, and neither will our client.
Thank you. Thank you, Mr. Kidd. Senator Williams, it's clear that the waiver process that has really been a deterrent for most states. I know Texas appears to be the only state that's applied. Ohio is not applying because of the waiver process and the complexities of it. As the only state that applied, do you believe it's time for the Department of Labor to go back to the drawing board and make a waiver application process more attractive to the states? And please explain what the waiver process has been like for your state of Texas.
Well, I don't know that I can speak directly to the waiver process. I know it's been a lengthy thing, and it's my impression that once the DOL issued their guidelines that more of the states seem to become discouraged about that. One thing I would encourage, though, is more flexibility, and I say that because What we've done with our job search requirements, for example, is that we allow our local workforce boards to set the number of job interviews that an applicant has to have on a monthly basis. And you know, we've found that that's worked better to allow them to set those, and our average is approaching 5 now, and so it's worked really well, and people are out looking for a job. I think it would work a lot better if they would just allow the states a lot more flexibility and allow us to move forward and, you know, get those impediments out of the way is the key.
Thank you, Senator. I yield back.